Hello friends, today we will discuss a case of medical negligence. On persistent request of our colleagues, we are making this video in English. Here the issue was related to the eyesight problems and the discussion occurred कि what should be written on the prescription of a doctor. Recently, National Commission has taken up this case as the revision petition and the final verdict was given on the 21st November. Initially, this was the case of UP Council. Complainant said, I experienced mild swelling in the right eye, so I went to the opponent 1. But opponent 1 referred me to the opponent 2. When I went to the opponent 2, he prescribed me steroids, which I put in my eyes twice a day, but there was no relief and my eyesight decreased. When I went to the doctor after 3 months, he changed the treatment and reported my eyesight to be decreased. But again, this treatment caused further problem and my vision again decreased further. I consulted some other doctor who explained me that this is due to cataract, which I had in the both eyes. And this was due to the long use of the steroid. I again went to the opponent 2. He abused me and thus this complaint is filed just to seek the compensation. In defense, opponent 1 said that I have never treated the patient and I just referred her to a specialist. Opponent 2 said that patient was having allergy due to prolonged uses of the lens. I have asked the patient to avoid the lens, which she denied and she continued wearing the lens. She was suffering from the giant papillary conjunctivitis, which mainly occurs due to extended uses of the lens. This requires steroid as a treatment and they have provided various papers to prove that giant papillary conjunctivitis is usually treated with the help of steroid. And in between, she has never come. District form, what they concluded, they recognize that opponent 1 has not treated the patient, so opponent 1 is not negligent. Patient has taken the treatment irregularly. And what she has done in between is not clear. Doctor has clearly written on the prescription that no to the contact lens, to which she heard or not is not clear. And this is not an expert opinion which patient has given. Patient has given the prescription of a doctor which says that the cataract occurred due to steroid uses. This is not due to that, this is due to the negligence of the doctor. So no expert opinion regarding the negligence is being provided by the complainant. So they dismiss the case. Aggrieved by the decision, patient went to the state forum and what state forum considered? State forum has considered the side effect of the medicines in the details and what they considered the steroids, the long use of steroid is harmful as per the prescription which is available. So it is always the duty of doctor to explain the side effect of the medicines, which here in this case, due to negligence and carelessness of the doctor has not explained the side effects of the medicines. So the mixim res ipsa liquator is also applicable here. District court has not considered the long-term side effect of the steroid uses. So they consider both party as the negligent one and awarded 7.5 lakh compensation to give to the patient along with some interest. Now aggrieved with the state forum decision, doctors went to the national forum. Opponent 1 said that I have never prescribed any medicine. Only allegation to me is to refer to the opponent 1. But the opponent 2, who is a specialist in eye, and nothing wrong I have suggested. So I am not negligent, but state forum has considered this as negligence. The case which complainant has taken in the state forum was some other case where the pediatrician and the pediatric surgeon both were considered negligent. So here the treatment in that case was given by both of the doctors, but here the treatment was given by only opponent 2. So in any case, I have not treated the patient, so I am not the negligent one. National forum considered it is always the duty of the complainant to prove, which lacks here. The expert opinion which the patient has provided never says that doctor is negligent. National forum, considering the previous all the judgments, they consider doctor is not negligent when he chooses one path of the treatment and if the treatment goes wrong. On another decision, they took that doctor cannot track all the patients. Likely in this case, the state commission considered that medicine was given continuously for the 6 months. But on viewing the OPD papers, doctor has given medicine only for a limited time, and the patient visited only twice or thrice in 6 month duration. Why she continued that medicine? There is no reason to clearly state that. And doctor has suggested only medicines for few days, not for continuously for the 6 months. And it is not possible to track all the patient. It is in fact the duty of the patient. When she considered that blurring of the vision is occurring, she should have contacted the doctor. But here she didn't contacted the doctor. She came only after 3 months. Doctor has clearly written on his OPD that no to the contact lens on OPD paper. But despite clearly writing that no to the contact lens, giving properly all the instructions, patient has not followed those instructions and she continued to wear the contact lens. So doctor was not negligent and the case was dismissed. Now we will discuss some take-home messages, friends. Always try to explain the major risk associated with the treatment or the medicines which we are giving. It is our duty to explain the major risk side effects of the medicines, and always write down after how many days you want to review the patient. Review after 5 days or review after 10 days. Normally the patient takes the medicine as such, whichever the prescription you have given for a long time, that this might benefit me, and they do not consult you again. So in cases of medico-legal negligence, whenever the case occurs, if you ask for the review and patient didn't came, it is the contributory negligence which can be proved easily. So always try to write the review days and always write the major risks which are associated with the medicines. Always write the clear instructions on the OPD slip. Like in this case, doctor has written no to the contact lens. So you have given proper instruction to the patient and you have documented the instructions given on the OPD slip. So whenever there is a problem and the patient is filing a medical legal case, there you can easily prove that I have clearly written this instruction and this instruction was not followed by the patient. So this is due to negligence of patient, not due to me. And referring a patient is not a negligence. If you are referring a patient timely or to some specialist one, this is not a negligence. Like in this case, the opponent one was also ophthalmologist, but he referred the patient to the senior ophthalmologist. So he referred the patient timely, not late, which may have caused the damage to the patient. So timely refer is never a negligence. Thank you, friends. You can contact us or you can mail us or you can write your comments on the video given below. You can message us on our WhatsApp, and please share and subscribe this video for the latest update. Spread these words so that every doctors know the law and they can practice easily. Thank you, friends.